Is everyone here? Hello?
Yes.
Now I'm frozen.
No, you look
Hello.
fine. You're not
You're
frozen.
not frozen to us.
Okay.
We can hear you.
Gentlemen, this is the Housing and Real Property Subcommittee. Today is February the 2nd. It's 5:55 p.m. Thank you for your patience.
Sounds like you're playing rather than recording.
Ladies and gentlemen. Is everyone there?
Yes,
Okay,
we're here.
okay. We are also live streaming now too. I swear I don't know what's going on. I really don't know what's going on. Okay. I'm so anyway, right now, ladies and gentlemen, we have a couple of bills that we're going to discuss. Matthew, let us begin, Matthew, with HB 86, please, Matthew.
Would it be possible to just dispose of the issues with HB 117 and 197 since it's very brief?
Simultaneously? Yeah, because they will be very brief. You're right. Go ahead, Matthew.
Okay, so with regard to HB 117 and 197, Scott Silverman is here again, and just looking for him to provide a brief update on the state of the amendments for those two bills. I believe there were some meetings, and I think it's probably just best to hear from Mr. Silverman.
Thank you. Matt, good afternoon, Mr. Chairman and committee members. So this morning, with Karen Strawn's assistance, Robin and I and Karen met with representatives of the insurance industry to attempt to ascertain whether coverage of the type that we propose to require of individual cooperative members is going to be reasonably available in the market. And their suggestion was to speak with a gentleman at the MIA, the Maryland Insurance Administration, who would be able to assist us in polling the carriers to determine the answer to that question. And we had a very good discussion with them, educating them as to the nuances of this issue. There was some discussion about the possibility, and I'm just going to say this, the possibility that perhaps we are rushing to legislate an issue that requires further study. And because it is fairly nuanced and complicated, and I'm not 100% convinced that the carriers fully understand what it is they'll be getting into. But there was some discussion that perhaps summer study might be the best place for this entire issue. Now, that being said, I have not broached that with Delegate Stewart or Senator Kramer directly. I did testify at the SB 145 hearing earlier this afternoon, and provided that same update as to where we think we're headed. And there were very good questions from the Senate committee, and that 145 is the cross file of HB 197. So there were very good discussions. Basically, they're waiting for us to get back to them with potential amendments after we're able to get some sense of where the carriers actually are. So I'm going to let maybe Karen pick up from here, because I think she may have taken it a little bit further and she set up a meeting for tomorrow morning. So Karen, take it away, update us further if there's more.
Well, I've spoken to Robert Barron at the MIA, and the liability does not seem to be a problem. And I'll discuss that further with Scott and Robin tomorrow. But basically the MIA agrees with our position. The concern is whether or not the property part of things will be taken care of. And that's something we're going to probably have to talk to them a little bit more about. but it does appear that there will be coverage available for for covering the deductible. And the question is only whether or not the property coverage will take care of things or not.
So the property coverage would, are you talking about the property coverage for what is already in the unit? Or are you talking about property coverage for the overall association?
Talking about property coverage for improvements and betterments.
Improvements, betterments. Okay, individual units. Okay,
Yes.
right. Okay. Delegate Healy and then Delegate Terrasi.
I would request, I mean, I'm happy to discuss and listen, but I would request that we not vote on this one today because the Greenbelt Co-op is going to be meeting on Friday to discuss this. And I'm waiting to hear back from them.
We had not intended to vote on this anyway, Delegate Healy, because there are too many loose ends, I think, for us to be voting on this particular topic right now.
Okay.
We're still gathering information, and I don't see how I could possibly defend this on the floor with all these loose questions right now.
Okay, thank you.
Let us know how the GHI meeting goes, and what day and time is that? Do you know?
It's the 5th. I guess that's Friday. I don't know what time, but they're going to let us know probably early next week.
That's on a Saturday. Okay. All right. If you could let me know, perhaps I can attend. I've got 2-3 meetings already on Saturday. Maybe I could squeeze that one in.
Yeah, I don't know how they're doing it. They might be doing it virtually. I just don't know. I didn't get that information.
Thank you, Delegate Healy. Delegate Terrasi?
Okay. I don't know why, but I'm just not following this. What is the part that now needs to be summer studied? That is, so there's some part of the study, some part, I don't understand.
Okay, hang on a second, Jen. Hang on a second, Jen. Let me have Robin come in and further explain some of the nuances that they're talking about now.
Thanks. So as many of you already know, we passed in 2009 deductible responsibility to owners in a condominium. And right now we cover under the master policy the unit as the developer originally conveyed it, absent improvements and betterments. The problem in a cooperative is that the shareholder simply owns a share. They do not own anything in the unit. And so we've been struggling with how do we shift to, responsibility for improvements and betterments when maybe they have no real property responsibility for those improvements and betterments. You know, whoever drafted the bill is trying to find some parity with the condo bill or the condo law and just shift it over to the cooperative. It's very difficult to do that because in a co-op, go ahead.
But I don't understand what's new from yesterday to today. Like what, we weren't talking about summer study yesterday.
No, we weren't.
So we were just talking about making sure that the insurance companies would cover the homeowner for that gap, the gap piece that they were, the 10,000 was it that they were supposed to be covering. So
Yeah.
what is now suddenly different from yesterday that makes somebody want to talk about summer study?
And I'll shift back to Scott in a minute. I think we are still struggling. So, you know, originally we had talked about making this a liability bill only. And then we were struggling with the liability because you're assigning a negligence standard to people living in a cooperative. And so then we were, well, how do we assign deductible responsibility to things that are originating in a unit if the owner or the shareholder has no responsibility for those things? I think one of the things that we are also struggling with is that the person who brought the bill has been after Senator Kramer for a number of years to have some sort of legislation passed. But the issue may only be an issue at Montgomery Mutual. That's a cooperative in Leisure World. It will be interesting, Delegate Healy, to understand after you meet with Greenbelt Homes, what their issue, if they have similar issues or if we are simply legislating a single issue for this cooperative that may cause more harm than it does good for cooperatives across the state. I really am concerned that we are doing things to solve one association's problem that may cause problems across the board with other cooperatives.
Let me go to Scott and then come back to you, Delegate Healy.
Yeah,
Okay.
I'm sorry. I'm sorry.
I'm sorry.
I'm sorry. Delegate Tressa, I thought you were through. I thought you were done.
I still don't understand what,
Yeah.
like, I understand the overall why you were concerned with the bill in the first place. But my understanding is that you worked it out with the sponsor of the bill and you were on board. So I still don't understand what changed from yesterday to today.
And let me try to explain that, Delegate Terrassa, that when we met with the insurance representative this morning and we started educating them on the issues associated with trying to achieve parity between the co-op and the condo world, it became clear to them that there are a lot of nuances here. One is trying to introduce negligence back into the equation, which we did not want to do, because in 2008 we changed the Condo Act to get away from negligence and to a no-fault standard. We wanted to have that in the co-op world also if possible, but the problem is, as Robin pointed out, if a member is permitted to make improvements or betterments to their unit, they do so with the knowledge that, one, they will become a fixture of the building and they will not be able to take them with them. Two, they may not be able to profit by the sale of their membership, particularly if it's a limited equity co-op. In other words, they may not, presumably if their unit is upgraded from somebody else's unit, they're going to fetch a higher price. That's not necessarily true in the co-op world. And also when the insurance reps began to understand that there's no real property ownership interest here, and they're trying to digest exactly when the individual policy is primary and when it's secondary, and exactly what they're buying into insuring. They're saying, look, this is a very nuanced issue. Maybe it's better to just summer study this and develop it more before trying to rush something through that may do more harm than good. That's where the summer study thing came through. But I want to be clear that we've been talking with the sponsors on both sides, and we are really trying to get both bills moving forward in a way that makes sense in the co-op world, and so that they do fit together properly, that they reconcile properly. The most important thing that we want to do is make sure that the carriers are on board with coverage for the individual members, because we don't want to create a situation where we authorize a co-op to pass through a deductible or require a member policy and the coverage isn't there to obtain.
Right, but that's what I thought you did confirm. So what is it?
Well, that's what we're still trying to do. We're still trying to secure that commitment. So it's there, but as we're trying to get the commitment for the deductible, as Karen pointed out, there's other issues that are coming to the fore.
Okay, that's what I'm trying to understand.
Saying, okay, right. What exactly are we insuring? When is this policy primary? When is it secondary coverage? I mean, that's what they're trying to get their hands around, because they don't want to go into a situation blind and, for example, think they're insuring, XYZ components of a unit, and then, next year the co-op changes their documents and makes the member responsible for more of the unit. Then the insurance company is now on the hook for more liability. In other words, they're trying to figure out how to define their liability as they write these policies.
Before I go,
and I also wanted to say, Marvin, I'm sorry, Delegate Healy, I know you mentioned Greenbelt the last time we met, was not trying to exclude them or keep them out of the loop, but we didn't want to reach out to them and involve them until we have more information. And we still feel like we don't have the whole puzzle put together yet, but are very interested to hear what their experience has been in this, scenario.
Oh, I mean, there was, if I could,
Yeah,
Mr.
sure,
Chairman,
sure.
I'm
Go
sorry.
ahead.
I reached out to the GHI, the Greenbelt Co-op, to tell them that these bills exist and to ask for their input. And, it's a co-op, so they don't meet all the time. So, but they're meeting on the 5th. They're going to take it up at their meeting. And I guess they'll have their attorneys and whoever they need to have advise them. But I don't know. I didn't try to explain the bills to them at all. I just told them they exist. And, after, like tomorrow, I will probably try to send them a copy of, or at least tell them about, because we do have the fiscal note now, so that has a more of an analysis involved. But I want to just say something about summer study. This is an election year. We will not be the same legislature when we reconvene in January. There will be a lot of new people and people who have not been through the discussions on this. It's never been the practice to have summer study in election year because it just doesn't hold over. You're not dealing with the same body at all. And we don't know how many people are going to turn over or which committees or anything else. We've had a lot of turnover anyway, year to year with people leaving. But an election year is a real sea change in the institution of the House and the Senate. So my advice is if you feel strongly, and I don't know what Greenbelt feels about it yet, but if you feel strongly that this is not ready for prime time, it is probably advisable to withdraw the bill so that it doesn't have a negative vote and that it will, and you can go back and work on it and get all your ducks lined up before it's reintroduced again. That's my opinion. Nobody else's.
Thanks, Delegate Hilly. And before we do anything like withdrawing a bill or holding it indefinitely, I want to make sure that we give the sponsors, plural, all of the information that we have so that they understand what it is that what our challenges are, so that they have the information to make that decision on their own. That takes me to my next point. I'm hoping that you, Scott, Karen, and Robin are talking with Vaughn and Kramer. Sounds like you are. I just want to make sure that they understand all of the information. I recall having a brief conversation with the senator, and he walked away saying the insurance administration said it was okay. That's why I put it in. And when he said that, it instantly raised a red flag to me, because in my mind, knowing the difference between the definitions of a co-op and a condo, to me, that didn't sound right at all. So I just left it alone. And I'm glad that you're having the conversations, because things are kind of going sideways, and I don't want it to go too much further. Lisa, Delegate Lisa Hess-Jones.
Yeah, I just want to point out that just so that everyone understands that CAI is reacting to legislation that they were not involved in at all before it was introduced and didn't know about it. So, Scott and Robin have spent hours upon hours with Karen trying their best to get this bill to a place where we're comfortable for it to be law. So I don't, I hear frustration amongst some of your committee members, but with, Scott and Robin, but they are doing the best and spending a lot of time on a bill that we didn't ask to put in and didn't, we didn't create. So I just want to make it clear, it's not a CAI bill, but we've made it a priority and we're trying our best to fix it.
Yeah, and it's important to note, so that the same law on the condo side was actually a LAC initiative for 2020, and it's one that I worked on and really championed. I am not against deductible responsibility to a condo owner or to a shareholder. I just need to make sure that we do this so that it doesn't come back to bite us. Because if the insurance industry and we don't even know how it's going to get written. There are an HO4 policy is for a renter or a leaseholder. An HO6 policy is for a condo owner. We don't even know how they're going to want to write this. And I think one of my biggest concerns is the litmus test here. Montgomery Mutual is full of retired folks in leisure world. What happens if their carrier opts not to insure them for this deductible responsibility? So, I think, Karen and is being very gracious and going to Robert Barron at the insurance department and making sure that all of the big box stores will be on board, understanding all of the nuances involved with the bill. And we're trying to tweak it to make everyone happy. And Delegate Healy, I really, really appreciate understanding where we are in an election year, because as a non-legislator, the last thing I want to do is push this over into summer study, and then we have to start all over, because you all have really given a lot of your time on this issue, and I would hate to have to start over with it.
Thank you. Thank you. All right. So the next meeting sounds like it's going to be tomorrow. And so there's going to be additional meetings following up. Is it okay if with the three of you, Scott, Karen, and Robin, if we put this back on our agenda for next week? Is that all right?
Sure.
Okay. And
if we can do this early in the week, I'm traveling beginning Wednesday, and I'm going to really be sort of out of pocket at that point.
okay. And if there's someone else we need to put in our discussions, in addition to the three of you, if you let me know whom that person is going to be, I can add them to the discussion as well. Delegate Terrassa?
Yeah, I just want to make sure that as those discussions are happening, that you're talking with a sponsor.
Yeah, I've already said,
Yeah,
I'm sorry, go ahead.
no, because I don't think he's been involved in this last piece of the discussion, or knew that was a change, that change in
Yeah,
direction.
they talked to him yesterday, I believe, or yesterday or today.
Not about this.
One of the three of you explained to me the last time you had a conversation with the sponsors and what the conversation was.
I spoke with Senator Kramer today and let him know what our discussion was this morning and where we thought we were headed. And I spoke and I emailed Delegate Stewart yesterday and let him know. And basically what I told both of them is we're still gathering information from the insurance industry to make sure that the coverage that we're looking to require is available. And as soon as we've made that determination, that we will put in amendments to the bills so that they will be in line with what we've determined is possible to achieve.
You okay, Delegate Terrassa?
We are updating them both.
Okay, I think maybe there just needs to be a little more communication, because I don't think the sponsor on the House side knew that this was the conversation we were going to be having today.
Okay. I'm going to ask one of the three of you to please reach out
I
to.
will make sure that I fill Vaughn in completely after we finish here.
Thank you.
Again.
And I want to make sure everyone understands my primary concern. I don't want to legislate us doing something and the insurance is not available. It doesn't exist. That doesn't make any sense to me. And I don't want to go down that road. So I think we've beat this to death. And I want to beat it some more next week. Please
Do we have to, continue to beat it? Like, I'm tired of beating it.
Wasn't that a song that was Michael Jackson? No. Yeah, Michael Jackson. Yeah, beat it, beat it, beat it. Okay. Anyway, I forgot we're being recorded. So let us now move from HB 117 and from HB 197 and move on to HB 86. Matthew, talk to us about HB 86 and talk to us, Matthew, about HB 86 and its amendments that have been offered and how those amendments on HB 86 address and amend the bill. Matthew, please.
Okay. I'm attempting to share my screen, although it looks like that might have been disabled. I think it might help if I could share a copy of the bill with the reprint.
Let me see here now.
Otherwise, I will be referring to the reprint document that I had sent out.
Wait a minute, let me see how I can do that. Let me go to you and make co-host. There. What do you think?
That seems to have worked.
I'll tell you that the more we do these things, the better I'm getting at it. If we keep doing these Zooms for another 6 years, I'll be an expert.
Okay, so is everybody now looking at a copy of
That is
HB
correct.
86 with the, okay, good. So this is what I had sent out earlier was the sponsors amendment to the bill. There are additional recommended bits of language by the Maryland Multi-Housing Administration. What I'm going to do is go through the sponsors amendment first, and then if there's time or at a future meeting, discuss some of the elements of the recommended bits from Maryland Multi-Housing Administration. So I'll direct you just to the first page here. These changes on pages 1 and 2 are technical.
If you want some more, just like.
These changes are technical
Thanks.
and are just necessary to implement the other provisions of the bill. Going to page 3, there was a change here in language from billing dates to service dates. And in speaking with a sponsor, I understand that he had worked with Maryland Multi-Housing Administration to make a change that would reflect information that's readily available and generally included in billing statements. That's the goal in changing from the billing dates to service dates language here. And then the largest component of the amendment starts on page 7 and is wholly limited to that bit on certain classes of individuals who are able to get out of a lease because of their status. Under current law, I think it probably helps to start with a discussion of current law, just to understand how the bill as drafted would change things and then do the amendment. In the current language of the bill, the protections of Title 8, Subtitle 5A were added for victims of stalking and establish a new form of notice to trigger the provisions of the subtitle, which would be a report of a qualified third party, which met certain conditions, and would alter the calculation of rent for the time that an individual holds the property after notice is provided. Now, in working with, there's a couple individuals on the call right now who I understand the sponsor worked with. I believe it's Melanie Shapiro and Dorothy Lenig, and I believe Zafar Shah might also be here. I just can't see everybody on the call right now. There had been a change in terms of how this section is structured a bit. There's still the provisions about the report of a qualified third or qualified, let me just go straight to the language, report of a qualified third party and adding that provision in. But the changes overall would first add a new group of qualified third party members, which would be an advocate from a domestic violence or sexual assault prevention or assistance program. Then the second change would be with regard to a report by a qualified third party. The amendment would strike language that the report indicate the tenant or a legal occupant is seeking assistance for physical or mental injuries resulting from an act of abuse. Some of the concern there, and I'm sure the individuals who worked with Delegate Stewart on this bill would probably elaborate on why that change is necessary, the movement to strike the physical and mental injuries component. And the third change is really kind of all throughout this section of the bill. And it would alter the application of the bill to a victim of abuse. So currently, this subtitle applies to a victim of domestic violence, the victim of sexual assault, and then the original language of the bill would have added a victim of stalking. Abuse would be defined as it is in family law article section 4501. So that would include acts such as an act to cause serious bodily harm, act to place a person eligible for relief in fear of imminent serious bodily harm, assault in any degree, rape or sexual offense, and there are several instances of that, or an attempted rape or sexual offense in any degree, false imprisonment, stalking, which would have been covered under the original language as introduced, and revenge porn. So this would be consistent with current language or language in current law pertaining to victims of domestic violence. Again, because the same definition of abuse is used, but current law would also require individual to be a person eligible for relief. This would replace the provisions applicable to sexual assault, would allow a final peace order to constitute sufficient notice under the subtitle if the underlying act was an act of abuse, and thus trigger the protections of the subtitle, and allow a victim of abuse to provide a report of a qualified third party as notice, triggering the protections of the subtitle.
Hang on a second right there, Matthew.
Mhm.
I want to see if we have any questions on that portion thus far. Delegate Healy.
Yeah, Matthew, this only deals with what, mental abuse, physical abuse, those kind of abuses. Does it also include abuse of people's economic situation or threatening to, make them, impoverish them or whatever, those kind of things as well?
So again, abuse is defined as part of the new amendment. That would be on page 7 of the reprint, starting around line 23. Abuse
Can
has
you put that on the screen, please?
It should be on the screen right now. So
Yeah,
I pulled up the language, not the.
What Delegate Healy, what Matthew has on the screen now is the definition of abuse as it is written in the family law article, not necessarily in the text that we have in front of us. So he's going back to.
Oh, okay.
Okay.
So here's part of the amendment. Abuse has the meaning stated in 4501B of the family law article. This is that definition.
Okay.
And I had read it off earlier, but obviously it's easier to read the components there.
Can you send that in an email or something so that I can look at it later and read it myself to understand it better?
Sure.
Just that section so that I can match it up. Thank you.
And what they did in the bill was just referred to the family law article.
Mm-hmm.
Yeah.
Okay.
All right.
And I believe, as I mentioned, there are a couple individuals on the call who had assisted Delegate Stewart with the crafting of this amendment. So it may be appropriate to allow them the floor for some additional comments at your discretion, Delegate Holmes.
The floor is open. Anyone that we had discussions?
So good afternoon, everyone. My name's Dorothy Lenig. I'm the director of the legal clinic at the House of Ruth. I'm not sure if Kathy Howard's still on the call, but Kathy and I were around in the days when this part of the law was first written way back. I'm embarrassed when, maybe 2010. And the idea of it was that if you have, say, a victim of domestic violence who's gotten a protective order, she may be afraid to keep going home because her abuser knows where she lives. And so the idea was that she'd be able to get out of the lease to protect herself. the delegate put in this bill, and when we read it, two things popped out. I love the idea of expanding the way that somebody could be eligible for this to these qualified third parties, but because some people don't get protective orders. But we really thought that if they went to a domestic violence program and got services there, that should also be a qualified third party. So we really wanted to add that category of people in. And then rather than start to list out all these definitions of abuse, since under the old statute, you could get this relief if you got a protective order, I thought it made much more sense to match up the definition of abuse to the family law article, since that's how people are getting these now. I don't know if that makes sense or not, but it would match. If somebody can get a protective order now for assault in any degree, then they could also be able to get this kind of relief if they had assault in any degree and they went to one of those qualified third parties and told them about it. So I'm happy to answer questions.
Sure. I've got a question. Matthew, if you could go back to HB 86 and go to page 14 for me, please, and go down to line 25. Right in that section right there, a landlord may not disclose any information provided by a tenant under this subtitle to a third party unless, and those two things. When an application is made for a new rental unit, sometimes the new landlord asks for rental history. And sometimes that rental history does suggest that the new landlord is going to reach out to the previous landlord. How would that scenario take place under what's written here in lines 25 through 28? How could that take place? And what could we do? I don't know. All right, that's one of the concerns that I had. Okay, so any other additional discussion on this portion of the bill so far? All right, Matthew, continue where you left off. I think it was page 7.
Yes. So again, generally, as I had mentioned, the subtitle, instead of being applicable to the defined victim of domestic violence, victim of sexual assault, or victim of stalking, would be applied now to this idea of a victim of abuse. And abuse would have the same definition as provided in the family law article, the one I pulled up. Mm-hmm. If you were to receive a protective order under the relevant subtitle, which is limited to certain people who are eligible for relief, that would be sufficient notice to trigger the provisions here. If you received a peace order where, and this is, you received a peace order, I apologize, I just need to find the language as it was. You receive a peace order under section 31505 of the courts article, for which the underlying act was an act of abuse, that would also be sufficient notice. And by peace order, it would be a final peace order, not a temporary peace order. And that final peace orders are under that section I just listed off. Or if you had a copy of a report by a qualified third party, which is a defined term, had been in the bill as introduced, although, as I mentioned, the amendment adds another class of qualified third parties, being an advocate for domestic violence or sexual assault prevention or assistance program.
Okay.
And then the definite, and when we talk about a report by a qualified third party, that's also a defined term here on page 8, starting at line 7.
Right. On the new item 4, an advocate from domestic violence or sexual assault prevention or assistance program, that would be primarily in your wheelhouse. Is that correct, Ms. Lenny?
Yes, so that could be, a paralegal kind of level person, or an attorney, or a counselor, or a hotline worker, somebody who's going to talk to the victim and hear the story and be able to write a letter or, something that indicates that we believe that the person is a survivor of domestic violence and has
Okay.
met this
Great.
criteria.
And I'm assuming that's something that you already do on occasion. Is that correct?
Yes.
Okay. And
Mr. Chairman, if I may.
Yes.
I'm Melanie Shapiro. I'm from the Maryland Network Against Domestic Violence. Thank you for having us here. So that language was actually taken from the address confidentiality statute. So there's provisions in our law that allows for people who are victims of domestic violence to shield their addresses. And so we took this language because these are one of the eligible parties for people to get that protection. So it's comes from existing law already.
And when those addresses are shielded, as I recall, the current address would come up as from the court system in Annapolis. Is that correct?
It comes up from the Secretary of State's office.
Secretary of State's office. Okay. Yeah, I kind of remembered something along those lines from back in 2010, Ms. Lemming. So
We shouldn't admit we go back that far.
So I remember it also, and I was here also.
And it was my bill.
There you go.
All right. So now, when an advocate writes a letter, what is the process? I mean, it's not one of the secretarial staff or something. It's got to go up the ranks. And how does that work? You know what I mean? Just the process.
Well, in the address confidentiality program, let's say a House of Ruth advocate helps the victim fill out basically an application, and it goes to the address confidentiality program. And assuming they've met all of the criteria, then the most important part in that is then the victim has to move to a confidential location. Because if you stay in the same place, he already knows where you live. So
Right.
this really dovetails with that. You have to be able to get out of your current lease and move to a new place to be able to protect the address.
I just wanted to make sure that there was a process, and you as you begin to know me, you begin to ask questions to prepare myself for standing on the floor with a microphone in my hand.
I love that. Thank you.
Sometimes my questions may seem like I am objecting to the bill, but I'm practicing to figure out what's going to be forthcoming. That's all I'm trying to do. Okay. Please continue, Matthew.
So that's ostensibly what the amendment would do. That there's not a whole lot more. I mean, what else the bill would do is all language as was introduced in the past. What's changing here is that that application provision, who can take advantage of the protections of Subtitle 5. The new method of notice was something that had already been included in the prior year's bills and hadn't really, it is in the same form as it was when it was passed out of the House last year.
Okay, fantastic.
They're really looking at application to who the protections of this subtitle would now apply.
Okay. Thank you, Matthew. Any additional questions for Matthew, and any additional questions on HB 86?
Well, there are, if you'll give me a couple, sorry, I don't mean to interrupt if there were other questions, but if you'll give me a couple minutes, I can pull, not a couple minutes, 2 minutes, I can pull up a draft of a document I made that had all of the MMHA recommended language.
Oh, sure.
Well.
Yes.
Okay, I'm just gonna stop sharing my screen for a second.
Yes, Delegate Lehman.
Mr. Chairman, are you looking for a motion?
No votes yet.
Okay,
Next week.
okay.
Yeah, next week. I appreciate your eagerness.
I'm ready. I'm all ready. Thanks. Good bill.
Yes, yes. Matthew? Oh, he's still, yeah. I just want to make sure we are all versed in the language that is here, and we can move it rather rapidly through the through our committee.
Okay, so this is the current language, and this was just language I pulled out of testimony from MMHA, recommended their position. I believe it was favorable with amendment. Let me pull that up just so I'm accurately portraying it. Yes, it was a favorable with amendment recommendation. This is just language from the testimony. The first amendment, which you can find on your House floor system, was on page, I'm sorry, I don't have this in a reprint right now, so let me just run that very quickly because it'll be easier to see. The first amendment I didn't include because there wasn't specific language that was offered. It was with regard to a recommendation to define a certain word that was used in the bill. At page 3, line 16, and that's the use of elements here. I would note that where it says elements, it identifies the elements that compose the landlord's utility charges to be allocated to the tenants under the ratio utility billing system. But the request generally was to for some clarity or a definition of what that term might mean.
Okay.
This second amendment was on the same page, line 28, striking some of the provisions here. The note that was provided was that in some jurisdictions, residential housing providers are not informed when meter reading dates occur, billing dates are related, and related due dates are also inconsistent. That would note that it says where practical, this information would be provided. But the concern was that wouldn't fully address some of the challenges that they might face. On the third recommended amendment was on page 4, in line 2, after request, this would place a period of time for complying with this provision of the bill. So under the bill, and this is actually related to the next recommended amendment in line 14, where so under the current language, a landlord who uses a ratio utility billing system shall, on written request by a tenant, provide the tenant with information to document a bill for utilities. That's language that exists in the bill right now. The recommendation was that a landlord would provide that information if the request was made within 7 days from the date the landlord provides the tenant a bill.
Got it.
And then the change above would be part of a notice requirement to tenants. In the next amendment would take place on page 5. And actually there was a couple other attendant changes I had to make. So the recommendation would be to strike this new provision J. I went back and also struck the subject to subsection J. This is my technical addition. If J were to be removed, then this language would no longer be relevant as well.
Right.
Amendment number 6 take place on page 10 in line beginning of line 25. And actually, I spoke with a representative of MMHA. I think there was a typo in the testimony. So the new location would be in line 5. Such that on receiving notice identified in subparagraph I of this paragraph, a landlord. So this relates back to those provisions in subtitle 5A, Title 8, subtitle 5A of the Real Property article, those protections for certain classes of individuals who would need to break their lease. And this relates to the duty to inspect the property. There was concern that the current provision suggests the landlord must inspect the property right away after receiving notice. I think so. MMHA had recommended that the inspection, there'd be language that added the inspection would take place within 48 hours or on a date specified by the landlord and tenant.
Okay.
And then finally on page 12, there was recommended language added at line 15, or to add language at line 15. And the effect of that would be to provide a date certain with which the property would be vacated
Gotcha.
as part of the notice.
All right. Any questions about HB 86, ladies and gentlemen? Well, I certainly am glad that we had a meeting yesterday, because we certainly would be here till midnight if we had yesterday's discussion and this discussion. Delegate Teresa,
Yeah, are we planning to move forward with these,
next week.
these amendments from MMHA? Because if that's the case, I kind of like to, well, I guess we'll have time to go through them, but
Yes.
kind of like to hear what a response from maybe Zephyr Shaw from Public Justice Center or somebody else that responds to these. I don't,
They're on the line.
could we maybe go one by one through them, or maybe just hear what Zephyr Shaw has to say about them?
Zephyr Shaw,
I'm here.
you're up.
I don't
Well,
know.
thank you.
Do you have these? I mean,
I don't have them, but I'm familiar from Mr. Greenfield's testimony at the hearing date. The issue with the word elements in the information that should be disclosed about billing is that if you list it out, if you just enumerated what the universe of elements is, you would actually be pinning landlords down to a list that their vendor may not be able to follow. So when we look at elements, landlords know what their vendors are providing. And so, for instance, I can share this with the committee in the interim. I've got these RUBS bills for one single unit for a client of mine over the span of 4 years. And over that span, there are 3 different vendors being used. Each vendor is providing different information about the utility charges. And so like the overall, what's encompassed here could be in a bill that there's units, measurements, rates, quantity, service period, so there's just differing amounts of information being provided. And ultimately what this means is that a tenant just needs to know what to anticipate will be in the bill. And so again, I think elements is not a very confusing term in practicality, because a landlord knows what elements are being provided to all their tenants by the vendor. And again, if you try to list them all out, you might be missing some. You might be pinning landlords down to have to be accountable to more than what they can be. And if the landlord groups have an idea of what an enumerated list of elements should be, then we should be able to look at that. The 7-day provisions that MMHA has asked for would basically neuter the bill. And so what we're talking about is the right of a tenant in one of these RUBS buildings to have a way to investigate any inconsistencies they perceive in their bill, inaccuracies or what have you. It's extremely unlikely, I'd say in my practice, that a tenant would have the perception that there's an inaccuracy, inconsistency, et cetera, within 7 days of a billing. They're going to call the AG's office to do a consumer complaint, or they're going to call legal aid probably well after 7 days. And in the course of that investigation, the investigator, the attorney is probably going to ask that tenant, well, you're showing me the January 2022 bill. Well, how does that compare to your January 21 bill, your January 20 bill, and so on and so forth. And so it's just unrealistic that you would even want to have that 7-day provision, because no one would be able to investigate then. And so this really inoculates landlords from having to provide any information. And if the problem is that they can't make a photocopy of a document that's maybe a few pages long that supports something that they're billing the tenant for, then I think that the answer isn't to limit it by time, but just to say, provide provide the right to inspect the documents. I think most tenants would be fine having to come to the leasing office to inspect documents and then making copies of the relevant ones. But there really shouldn't be a 7-day period.
So your suggestion is what in terms of that 7-day provision?
I'm suggesting that it's not really a technical amendment. It is actually just anathema to the spirit of these provisions completely. And I'm just saying to Delegate Holmes that, if the concern is that there's an onerous burden to produce documents that support the bill, that the better fix would be to just allow the tenant to inspect the documents and make a copy of whatever are the relevant documents.
Okay.
And I'll say too that, when it comes to allocated billing of energy, so gas or electric utilities, COMAR already requires landlords to keep these records. I believe it's for at least 2 years, and to allow inspection of documents for at least 2 years. So there's that, and I don't, this would be a 7-day period would run afoul of what COMAR already has.
Okay, what about, I wasn't able to follow quickly enough the other amendments. I think you went through 1 and 3 maybe, or maybe 4, but I don't know if Matt can go through or Mr. Mickler can go through the other
Sure.
ones that he didn't respond to, because I guess I wasn't able to keep up with them as quickly as you were going through them.
Sure. So I believe at this point, Mr. Shaw has responded to what would be amendments numbers 1 through 4 in MMHA's testimony.
Okay.
The 5th amendment in MMHA testimony and would be to, what I have here, strike the language on page 5, lines 33 through 36. So this provision was specific to the security deposit language in current law. So what would be provided is the new language would require a statement of cost be provided under subsection G1. 8, sorry, with the strikeouts, it's a little hard to read. H2, Roman numeral 3, and I7 of the section, because there are statements that are required to be provided under these sections. Shall, where practicable, include supporting documentation, including bills, invoices, and receipts that identifies materials or services that were provided. And this is with regard to when portions of the security deposit are being withheld.
So just Mr. Shaw, are you familiar with that and have some response to that? Because
right. And again, the response I think is that it's essentially kills the reform that's being proposed in the bill, in Delegate Stewart's bill. And the reason for that is that the difference that you're trying to make in this bill is that rather than have simply sort of line items that are provided to the tenant when the withholding of the security deposit has been made, without documentation to support what those deductions are. This is putting the onus on the landlord to provide the supporting documents for the deductions that they've put in those line items. Okay, so it's a difference between a list with no support and a list where there's actual support. I think the testimony for this amendment was, and I'm sorry, Aaron, if I get this wrong, the testimony was basically, landlords aren't going to have time to get invoices, and they have only 45 days to provide the release of the security deposit with the deductions. But essentially what that means is that they don't have support for the deductions that they've already made in that 45-day period. And it can't be. So again, this is an area where I think that if you're going to pass the bill, with the spirit that's behind it, you would want to have the supporting documentation provided, and that you wouldn't wait for there to be litigation under 8-203 of the real property article. Because only through the litigation would a tenant actually be able to see those invoices. I mean, you can't expect that tenants want to go and sue the landlord, or that they'd be prepared to do that if they have to.
Okay,
I
can
just
we go
wanna-
through the last two?
Sure,
Oh,
and
sorry.
before doing that, I'm happy to go through the last two amendments. Before doing that, I would like to point out that MMHA did provide testimony as to why the amendment was needed with each amendment. That is in the MMHA testimony, and I believe there also might be a representative from MMHA
Yes.
here.
Yeah, although what Mr. Shaw said is what they said is that depending on the amount of time it takes the landlord to obtain invoices from contractors and subcontractors. So that is, I believe Mr. Shaw's recollection does reflect, I have in front of me the MMHA testimony, but
I understand. I just want to make clear if anybody's looking for an MMHA statement, it is with the testimony. There are also representatives of MMHA here. But anyway, moving on to amendment number 6, that was on page 10, line, sorry, I keep doing this. It's line 5 now. So upon receiving the notice identified in subparagraph I, which, sorry, Roman numeral, it would be the notice under 2I. If a tenant vacates the lease premises earlier than 30 days after the date the tenant provides written notice of an intent to vacate, the tenant shall provide the landlord with a written notice signed by the tenant and notarized by first-class mail or hand delivery stating that the tenant has vacated the lease premises. So this, in effect, would trigger, be the end point of when the individual is responsible for paying rent. So under current law, you would be responsible if you're vacating under the subtitle for rent for a period of 30 days. And this is trying to tie everything back to use, how long the individual who's ending the lease is actually using the premises. So the provision here was a request to add language specifying that the inspection didn't necessarily have to take place immediately. Without the language, it would read, on receiving a notice identified in subparagraph Roman numeral 1 of this paragraph, a landlord shall inspect the lease premises. And if the tenant has vacated the lease premises, provide the tenant with a written statement that specifies this information. So this would place a limit or a period of time where the inspection would occur within 48 hours or on a date specified by the landlord and tenant. And again, the testimony that was provided was the current provision as drafted suggests the landlord must inspect right away.
can we get a response on that?
Mr. Shaw?
I think that our view of this is that it should be consistent with the other two existing statutes related to early termination based on domestic
I'm sorry,
violence.
speak up just a little bit louder.
So we have sections which are similar to this in the real property that would be different from this. So I think you would want it to all be consistent. So whether the grounds are sexual assault or domestic violence, I think that was, when we looked at this, that was our main concern, was that we didn't want that phrasing to be different in different parts of the real property article. So
this wouldn't, especially with the amendment that was offered, this would be the standard that would apply under all
Across the
these
board.
cases.
Right.
Across the board.
Right.
And it would be
board.
the same even if the sponsor's other amendment, which would apply this to abuse generally, were to take place. This is changing the current process.
Right.
So it would be of general applicability.
Correct. That was my understanding too.
okay.
Right. Anything else, Delegate Terrassa?
I think there is one last amendment.
Yes, on page 12. In line 15, the general provision here would be, this would provide the landlord with some specificity on the date by which the tenant intends to vacate. If you add this date certain language
Okay.
to the notice requirement. I am just going back up a little bit. So the notice requirement that was referenced is the provisions under 85A02, or it will may terminate the tenant's future liability under residential lease under 85A02. The tenant provides a. Oh, you know what? I'm sorry. Actually, let me take a step back with regard to amendment number 7. If the subcommittee were to adopt the provisions put forward by by Delegate Stewart, this amendment would no longer be necessary because all of 85A05 would be stricken from the bill. So my apologies.
Thank you.
Looking at two separate documents.
And
amendment number 7.
And that portion of striking 8585 is on page 12, starting with line number 10.
I would have to pull up the.
Oh, yeah, I got it right here in front of me. That's where it is. Yeah. Okay.
So I think what you're referring to is, and I can show you the provision has been struck.
That's correct.
So
struck. That's right.
That is my error.
Okay. All right.
Okay, thank you, Mr. Chairman. Appreciate it.
Sure. Any additional discussion from anyone on the call?
Mr. Chairman, do I get a chance to speak? Or,
Yes, indeed.
I know Mr. Shaw does a very good job speaking for both of us.
That's why I opened it up. I said, any discussion from anyone on the call?
Appreciate that. So the first amendment, the elements, this is, I guess, the third session perhaps that we've taken this bill up. And, you know, each time we've asked for an amendment for clarification and the sponsor's been unable to give us what the elements are. And, you know, it would be helpful to have that information. If it's a subcommittee in the subcommittees, if it's the subcommittee's wish to not define it, so be it. We'll leave it open. But it seems to me that we'd want to know what the elements are. Amendment number 2 is particularly problematic. While the sponsor did strike, as I understand, billing dates in exchange for service period, he left in meter reading dates, due dates by utility. The problem with that is we're going to have folks in Baltimore City automatically in violation of this provision out of the box because they don't give us meter reading dates. They don't give us due dates by utility. And if and when they do, they're months and months behind. So we're automatically in violation of that provision the moment this bill passes. And then I understand the arguments about the 7 days. Clearly, you know, I get Mr. Shaw's argument, and candidly, you know, we see, you know, I know where the committee is. They voted on this bill last session without that language. So I'd expect the committee to do the same. Amendment number 5, dealing with the security deposit. Look, there's significant delays in materials, in services these days. You know, there's a 45-day clock that starts to run once the tenant vacates the property. We can get numbers on the phone about what the cost might be, but it's harder to get, as the bill actually states, some more supporting documentation, including bills, invoices, and receipts that identifies materials or services provided. And all I'm suggesting is that is also a potential provision where we could be in violation if we don't have it within 45 days. And if we don't, then we face, my understanding, of treble damages. So we've got serious damages that we have to face if we don't meet that 45 days. And then
if I could just add something, Mr. Greenfield.
Yes, sir.
And I'm going to give the subcommittee a real life example that just happened to me 2 months ago. I had a tenant, most of you know, this is my line of work. Tenant moved out, proper notice from the tenant, everything was proper. I had information out trying to hire 4 separate contractors, at least to give me an estimate. All of them said, I'm too busy, I'm not interested. It's an issue that has to be dealt with, and I'm not quite sure how to deal with it, but I'm just letting the subcommittee know that materials are scarce in some cases. It took me 2 weeks to get a handrail for one property. Materials are scarce, and sometimes contractors are too busy, and the 45 days is really bumping your head against the time clock. Delegate Teresa. Delegate Teresa.
Sorry, I was just trying to understand the 45-day.
The 45 days is you have until the time frame that the tenant moves out, 45 days, you have to provide them with a letter that explains to them the cost of the repairs, what all of their default in their security deposit. What did you do to this house to cause a default? Did you put a hole in the wall? Did you take you moved out and you took the range with you? How much is it going to cost to replace that?
So the issue isn't how long it takes you to get the receipt, it's how long it takes to get the work done.
Well, you can't do one without the other.
Right, but I guess I thought Mr. Greenfield was arguing it was taking a while to get the receipts.
Well, you can't get the receipt if you can't get the work done. Right? So
yes, but that's not what I understood him to be arguing. But
I was
okay.
making the point that there's a delay in services and goods. And so all of that is a factor in the 45-day clock.
Okay, Mr. Shaw.
And I just want to clarify that if the landlord doesn't have the work done and they don't have the receipts or the invoices for the work or the materials, then they don't know what they're deducting from the security deposit.
That's correct. I agree.
Right. So
and I'm not arguing that point. Your point is correct. If you can't get the work done and you can't get the receipt for the work, then you can't deduct that from the security deposit. I agree with you 100%. And I'm not saying that that's wrong. I'm just saying that in today's world, there's sometimes a difficulty getting the work done and getting the receipt. That's all I'm saying. You know, you're what you're saying is correct, but I'm just saying it's difficult. But anyway, that's a different thing. I don't want to put my continue, Matthew.
I believe Mr. Greenfield was continuing through the amendments.
Yeah, and then just on, yeah, and just, I'm sorry, thank you. And Matt, thank you for reaching out last night. I really appreciate it. And then on amendments 6 and 7, it's really just trying to give the housing providers some specificity on, you know, on exactly when they are able to do what they need to do. So within 48 hours of a date specified by the landlord and tenant, that they can go into the unit and do what they need to do. And similarly, that the resident provides a date certain when they will vacate. So we think, you know, look, this bill puts a lot of burdens on housing providers. We think these are simple requests in amendments 6 and 7.
Mr. Shaw, you have anything you want to comment on 6 and 7? I'll get right to you, Delegate Healy. Mr. Shaw, on 6 and 7?
No, I think what I was trying to describe earlier was the issue with a date certain, but it looks like all the 3 different sections here are being folded into one. So I think it resolves.
Okay, thank you, sir. Delegate Healy?
Yeah, thank you, Mr. Chairman. My question is about this 45-day period. The purpose of this bill is to protect somebody who is being stalked and terrified and has to leave where they live to escape for their lives. And so if they leave in a hurry and they're gone, I guess you don't want them to be on the hook, liable for something that happens after they leave. You know, they leave on one day and their stalker breaks into the place where they live and does all kinds of damage to it after they've left. It's not their responsibility. They shouldn't have to pay for it. there should be some kind of date where we're leaving, take pictures, do something to set in time to protect that person from outside influences, or even if the landlord, the owner of the property decides that they're not in any hurry to re-rent it, and they let it sit vacant for a long time, and it deteriorates and it gets in bad shape. And then the person who moved out in fear of their life shouldn't be
Yes.
responsible for that either. So those are the issues I think that I see trying to get a balance going on. You don't want to be unfair to the landlord. You want to make sure that they can get what they, if there was damage done. But at the same time, there's that window of time after they move out when the place is vacant. And if there's nobody in the building to check on it or secure it or make sure that it's protected, there has to be some way to say, as of this day, this is all you're responsible for, tenant. And after that, it's on somebody else.
I agree, Ann, Delegate Healy, and I think there's some provisions in the bill. Mr. Greenfield?
Do you want me to respond to Delegate
Yes,
Healy?
yes,
I
yes.
guess the only point I would raise is that this provision goes beyond those who are victims of stalking. This applies to all residents. And so so it's not just in those specific narrow cases, but your point's well taken. And obviously we wouldn't want to hold a resident to anything beyond the end of their tenancy. That wouldn't be appropriate. And that wouldn't be what we're seeking to do.
And one of the provisions also in current law, I don't quite know where it is, but one of the things that most professionals do is when the tenant writes a 30-day notice, when the tenant provides the landlord a 30-day notice, the landlord sends a response. Thank you for your 30-day notice. By statute, I think it's in the statute someplace, I have to have an inspection on your property within 5 days. This is the date and time of my inspection. If you want to be there, this is the date and time of my inspection. And I think that would probably take care of your concern.
Thank you.
Sure. Delegate Terrassa.
Okay, thank you, Mr. Chairman. I hate to dwell on this 45 days, but right now in the law, you have to return the deposit in 45 days. Is that
Yes, ma'am.
correct?
Yes, ma'am.
Okay. And if you're going to deduct an amount for something, how would you know how much to deduct if you don't have bills or estimates?
You don't. You have to have the bills and the estimates.
Right. So then I don't understand what, oh, sorry, Mr. Chairman.
No, go ahead.
Yeah, so I don't understand what could be the problem with providing those details where practicable to the tenant. I don't understand, like, what would be the problem if you're withholding it from the tenant?
Mm-hmm.
There has to be something you're basing it on. And so you must have the thing you're basing it on. So why couldn't that be provided to the tenant where practical? I guess that's what I'm trying to understand. It says a statement of the cost provided under this other section where practicable, including supporting documentation, including bills, invoices, receipts that identify the materials or services provided. So I don't understand if you're withholding it, what else? You'd have to have something you're basing it on.
I agree. You do have to have something that you're basing it on. I think that the tenant should receive documentation on what the default is being based on. Yes.
Right. And I think that's what I think that's all this says. And I think my understanding is MMHA doesn't want that to be the case because they're concerned it would take them longer to gather that information. But I don't understand how they could take them longer to gather that information if they've just used it to decide how much to withhold from what they're returning to the tenant.
Mr. Greenfield?
Look, it's a different world now than when this was first enacted. You have, again, significant delays, and this puts on an additional level of responsibility where the work may have been done within the 45 days, and we may have a quote or we may have some initial invoice that we could certainly share. But I think the challenge is that you're not expanding the 45 days, you're keeping it 45 days, and you're adding these additional documentation at a time when we're not sure we're going to be able to get that documentation ready for a tenant to supply them at that time. And I think given the delays, it's a significant concern. It's already hard enough, as the subcommittee chair referenced, to get work done in 45 days. And so
Identify the additional documentation as requested, Mr. Greenfield.
what's that?
Identify the additional documentation that is being requested.
Well, the invoices, receipts, specific materials and services provided, that's in the statute. That's not necessarily in the current statute. So you're requiring more documentation at a time when services and goods are delayed. And so contractors and subcontractors, we're just going to have to make sure it puts a greater emphasis on getting that material specific to the language in that provision back to the landlord in time within the 45 days.
It doesn't say, it just says supporting documentation, including bills, invoices, receipts that identify the materials or services provided. And it says where practicable. Like for the life of me, I don't understand.
Yeah.
I mean, and if you have an issue with the 45 days, it seems like that's like a different bill. Like this is just saying you have to have documentation before you would take money out of somebody's security deposit, and you have to provide it to the tenant so they know why you took money out of their deposit.
Right. Well, I could submit an estimate within 45 days saying this is what I have, but it may be harder and longer for me to get an invoice or a bill that identifies the specific materials and services provided from the contractor. That's what I'm saying. And frankly, the language where practicable, which is one of Delegate Stewart's favorite things to insert into bills, frankly calls out for litigation. It's an opportunity to litigate. And I think that's problematic in and of itself.
I recall you adding that to several bills, but okay.
That's not true.
Okay, thanks.
You complete, Delegate Ferrasa? All right, Mr. Shaw.
I think that this would actually prevent litigation. A lot of the litigated issues you'll see in this line of work is, for instance, where the tenant receives their security deposit minus $500 for carpet cleaning. Well, what carpet cleaner for a 1-unit bedroom is going to charge $500? If there is an actual receipt, for that the landlord shares with their itemized deductions from the security deposit, you're going to avoid having to litigate that issue. So I think that it just cuts both ways in some sense. Like for a lot of tenants, if they get the information with their security deposit, if there's parts of it deducted, they're going to see that there is a rational basis, that there is evidence that would potentially become evidence in a trial, and they'll just want to avoid that because they're unlikely to have better evidence than what they just received in the mail from the landlord.
Delegate Lehman.
Thank you, Mr. Chairman. I just want to go back to the where practicable languages only because I am one of the few people, in my screen where I see Mr. Shaw and there was Mr. Greenfield. I'm not an attorney, and Delegate Terrazza, who's brilliant and gets into the weeds of these things, and I appreciate that. But yeah, the comment that, so did the sponsor put in the where practicable language? And I just, from my limited, legal knowledge, I was interpreting it the way Mr. Shaw did, which was that it would be, more likely to, deter, if that's the right word, a filing, a legal filing. But where did that? Who suggested that language? The sponsor, or?
According to Delegate Terrazza, it was me, but I'm fairly sure that's not the case. Delegate Stewart put this in last session or the session before in a separate section of the bill that still remains in the body of the bill. I can't point it out right now, but my only point, Delegate Lehman, is that where practicable raises the question legally, well, was it factually practicable for you to get the supporting documentation? It raises the issue as another issue that could be during the course of litigation. You know, that's the point that I'm raising.
Okay,
Okay, well,
The,
that, I guess that's helpful, but, okay, that's all for now, Mr. Chairman.
thank you very much. Delegate Trusser?
Where practicable is an out for you. That's what that is. I didn't say you put it in there. I am certain that in my years of working with you, that you have asked for that language in the past, because where practicable is an out for the person being required to do something. If you took that out, then you'd be required to do it.
Okay.
It's not something that harms you. It's something that helps you.
All right, let's take a look at those. Let's take a look at those provisions where they are in the bill, and we'll come back to that at another moment. Mr. Greenfield, you have anything else you want to add to the discussion?
No, I really don't actually. Thank
Mr.
you.
Shaw?
no, thank you for all your time. Appreciate it.
Sure. Matthew?
I do not.
All right, thank you very much. All right, ladies and gentlemen, it is 7:21. I'm already 21 minutes late for my next appointment. We will gather again next week. Now, I do not believe that we're going to have the ability like we did this week to have 2 meetings in 1 week. And that's going to be unfortunate because you see how long it took us today and yesterday. Take those 2 time frames, put them together. That's how long we would have been here tonight. Delegate Wells, don't shoot me.
I was just going to ask if other bills moving forward will get this amount of attention. I have a couple coming up next week myself. Just put it out there.
We shall see.
Okay.
All right. Good night, everyone. Oh, I'm sorry, Delegate Lehman.
Really, really quickly, can you be clear? Are we voting on some bills next week? Are we
Yes,
doing
ma'am.
more?
Yes, ma'am.
Okay, in both sessions or just one of the sessions?
I'm not sure we're going to be able to have 2 sessions next week because we have a lot of bill hearings next Tuesday.
Okay, so you'll send us an updated list of the bills to be voted on?
That is correct.
Oh, okay, thank you.
You're welcome. Have a good evening, everyone.
Good night. Thank you.
Next week, same